Everything you need to know about residential long-term care in Kentucky. Shared with you by the Kentucky State Long-Term Care Ombudsman Program, housed within the Nursing Home Ombudsman Agency of the Bluegrass, Incorporated. This audio provides general information and is not a source of legal advice. For specific questions about legal matters, consult your attorney or a legal services provider. Don't delay seeking legal advice, disregard legal advice, or begin or discontinue any legal action because of information provided in this document. This information is made possible by state and/or federal funding provided by the Department for Aging and Independent Living. NHOA gratefully acknowledges the Kentucky Bar Foundation and the United Way for their support in producing this booklet. General information. What is an ombudsman? Ombudsman is a Swedish word for advocate. Federal law gives ombudsmen the power to intervene on behalf of residents of long-term care facilities. Ombudsmen are trained to impartially investigate and resolve residents' concerns. They also provide information and make referrals to community resources. Your ombudsman is not an employee of the nursing facility or government agency. Your ombudsman works for you, free of charge. What can I expect from an ombudsman? Your ombudsman will regularly visit your family member in the nursing facility and provide education about residents' rights. Because their sole focus is improving the quality of care for residents, ombudsmen often are the first to notice changes in health and well-being. Is there an ombudsman in my area? The Nursing Home Ombudsman Agency of the Bluegrass serves 17 counties of central Kentucky that comprise the Bluegrass Area Development District. It is one of Kentucky's 15 state-designated Area Development Districts, ADDs. All 15 area development districts have an ombudsman program. Please call or visit www.ombuddy.org for contact information for ombudsmen in other districts of the Commonwealth. Our vision. The Nursing Home Ombudsman Agency of the Bluegrass envisions a world where aging and disability come with value, ease, dignity, and hope. Our mission. NHOA's mission is to demand the highest quality of care for long-term care residents through empowerment, support, education, and advocacy. Our goals: protect the rights of long-term care residents, identify, investigate, and resolve residents' concerns, empower residents to make informed choices, work to enact laws protecting older and disabled Kentuckians, visit residents as often as possible. Our clients. There are more than 40,000 long-term care residents in Kentucky. 12% are under the age of 65. 50% have Alzheimer's disease or another form of dementia. 60% have no visitors, ever, from outside the facility. 70% are impoverished. 80% are women. Kentucky's ombudsmen make thousands of visits each year to long-term care facilities. They identify, investigate, and work to resolve hundreds of problems and complaints. The majority of issues center on quality of care, resulting in abuse and neglect, injuries, falls, pressure ulcers, and failure to respond to call bells, follow physician orders, and notice changes in a resident's condition. About this guide. Your 80-year-old mother needs more care than you're able to provide at home, and you're thinking about moving her to a long-term care facility. What do you need to know to make the best decision for her? We answer that question and others in this booklet. In fact, we help thousands of individuals and families every year with nursing facility placement, care planning, and questions about legal rights, abuse, Medicare, Medicaid, and other concerns. Residents and families tell us the first few weeks after moving into a nursing facility can be challenging, partly because of the unknown. They don't know what to expect. They aren't prepared to deal with the issues involved in moving from home to a long-term care facility. The transition can be difficult for everyone. We want to stay in touch with you. For updates and information, visit www.ombuddy.org. To receive our newsletter and information about more urgent matters, call or email us at nhoa@ombuddy.org, and we will add you to our mailing list. For questions about other matters, please call us at the number provided. Getting into a nursing facility. Do I need consent from my loved one to place him or her in a nursing facility? The first thing to do, if feasible, is discuss the need for placement with the friend or family member who needs help. It's unethical to force an individual into a nursing facility or other long-term care facility against his or her will, as long as he or she is considered legally competent and has decision-making capacity. Once the issue of consent has been addressed, placement choices depend on several factors including payment source, initially and long-term, level of care resident needs. Families, chosen families, and loved ones may be tempted to make placement decisions that go against the wishes of their loved one. Sometimes, families think they must coerce placement or conceal the true nature of placement. Being open and honest with the prospective resident is critical. In time, Uncle Charlie may forgive loved ones for moving him into a nursing facility against his wishes. However, it will be more difficult for him to forgive anyone who tricked, manipulated, or lied to him. To avoid this, families should discuss health, financial, and work situations in advance to determine the best and most realistic options. In some cases, it may be wise to talk with an ombudsman, social worker, or attorney to determine who has ultimate responsibility for decisions when the prospective resident is a legally competent adult with decisional capacity. A legally competent adult who lacks decisional capacity, or an adult who has given permission for someone else to make decisions on his or her behalf. Prospective residents, even those with dementia, should be involved in all discussions and decisions. Failure to include them can be very upsetting and make the adjustment to placement much more difficult. Individuals with dementia may hear only portions of the conversation and misinterpret them with unpredictable reactions. Some individuals choose to live in a nursing home. For people who have been socially isolated and those in fragile health, it can be a positive experience. These residents value the congregate setting and find it reassuring to have nursing assistance available. Are there options other than moving into a licensed long-term care facility? Yes. Many individuals choose to live at home with a combination of in-home services. The Bluegrass Area Agency on Aging and Independent Living offers information about senior centers, adult daycare, family caregiver support programs, and home care services. The Bluegrass Area Agency on Aging and Independent Living may be reached at 859-269-8021 or toll-free at 1-866-229-0018. Visit www.bgadd.org to obtain a copy of Pathways, a comprehensive guide for older adults and their caregivers. Remember, generally, it's useful to think about how close a potential facility is to the family members who will be providing support. Ultimately, a facility close to the family may be more desirable than one far away, regardless of differences in the quality of care or the attractiveness of the facility. If families are close to facilities, they might visit more often and can support the resident in his or her quest for quality care and quality of life. How do I find long-term care placement for someone who's in the hospital? For hospital patients, the ultimate responsibility for finding placement lies with the hospital or discharge planner. An HOA recommends working with the discharge planner in the search for a facility and visiting facilities being considered prior to placement. In some parts of Kentucky, nursing facility beds are scarce, and there's little choice for consumers. From the nursing facility's point of view, individuals who have Medicare reimbursement and are being placed by hospitals are the most desirable prospects. Placement from a hospital is generally easier than placement from home setting because some long-term care policies pay benefits only when the prospective resident is going to the nursing home immediately following hospitalization. The nursing facility may be able to secure Medicare reimbursement for up to 100 days, depending on the resident's diagnosis and progress. The hospital sends required admission documents such as recent diagnoses and assessments to the nursing home. Buyer beware. If you give the responsibility of finding a facility to the hospital, you may have little say in the choice. Hospitals have strong financial incentives to discharge patients once they no longer need hospital care. What is the process for moving from a home to a nursing facility? Prospective residents should provide facilities being considered with copies of their medical history, results of a recent physical, a list of medications, and proof of being seen by a physician within 30 days of admission. As you attempt to gain admission for your loved one, contact the facility regularly and politely to stay in the forefront of the mind of the person in charge of admission. Don't rely on a facility's waiting list, often a tool to pacify families of Medicaid-eligible residents. In Kentucky, nursing facilities have the luxury of picking and choosing among applicants. They tend to choose applicants who best serve their needs. Sometimes families focus on finding special care units for residents with memory disorders or behaviors that may be difficult for caregivers to manage. Federal and state regulations require facilities to have individualized care plans for each resident. Facilities are responsible for meeting the resident's needs, regardless of where the resident lives within the facility. Therefore, in most cases, residents and families shouldn't have to pay a surcharge to receive care that's required by state and federal law. How does a resident move from one nursing facility to another? Responsibility for placement at a different facility lies with the person or entity initiating the transfer. Resident-initiated move. Responsibility for securing new placement rests with the resident if he or she initiates the move. However, the Social Services Department of the current facility is required to provide assistance. In an assisted living community, personal care home, or family care home, the administrator may give assistance, but is not required to do so. Facility-initiated move. When the facility initiates a transfer, regardless of the reason, it's responsible for securing new placement for the resident. The facility also must adhere to laws regarding proper transfer and discharge. A resident who has been asked to move but doesn't want to move should contact his or her ombudsman. Visit www.medicare.gov/nursinghomecompare for information about nursing homes in your area. Contact NHOA for a list of nursing facilities in the Bluegrass District. Selecting a facility. Questions to ask. Location. Is the facility close enough to visit on a regular basis? Is the facility easy to reach during bad weather or an emergency? Personal preferences. Will my loved one be comfortable with the room layout and decor? Are residents dressed appropriately and well-groomed? Do residents appear to be comfortable and content? Are there other residents with similar interests or backgrounds? Helpful services. What types of therapy does the facility provide? Is the ombudsman contact information prominently displayed in the facility? Are there transportation services? Are there religious or spiritual services? Are residents' rights posted in the facility? Is there a barber or beautician? Engaging activities. Are planned activities posted? Does the facility offer activities that my loved one will enjoy? Is it okay to visit and participate in activities with residents? Caring staff. Do I see staff interacting with residents in a friendly and warm manner? Is staff available throughout the facility? Do staff appropriately supervise residents? Mealtime. Is the food appealing to my loved one? Are residents eating and enjoying their meals? Is staff available to help residents who need assistance eating? Appropriate surroundings. Are the surroundings clean and neat? Are there offensive odors in the air? Is it noisy because of loud voices, loud public address systems, or TVs? Do I notice unanswered call lights? Do common areas look inviting and comfortable? Is there adequate space to meet residents' needs? Are residents' rooms home-like and personalized? Ask other families. Is there an active family council at this facility? What do other families think of the care here? State inspections. Are the last 3 inspections available for your review? How will I pay for long-term care? Private pay. Nursing facility residents who don't use Medicare benefits and aren't eligible for Medicaid to pay for their care are considered private pay. Private pay residents may use savings, investments, proceeds from the sale of a home, long-term care benefits, or other income to pay the bill. In this case, the family or prospective resident should carefully consider the following. When the money runs out, will I medically qualify for nursing home placement? A private pay resident who runs out of money before becoming ill enough to qualify for Medicaid may not have the option of remaining at the facility. There are no limits to what the nursing facility can charge private pay residents. Therefore, it's important to request an itemized list of services and costs. Families of private pay residents should request a Medicaid-certified bed if they think their loved one will qualify for Medicaid coverage in the future. In some facilities, all beds are certified for Medicaid. Individuals and families with few resources should avoid facilities with few or no certified beds. It is illegal for the facility to directly inquire how much money an applicant has. However, facility staff are permitted to ask when the resident will become eligible for Medicaid. Families may want to consider other community services or long-term care options until nursing facility placement becomes a medical necessity. Beds are certified to participate in the Medicare and/or Medicaid programs. Federal standards are used for this certification. Certified beds can have the following designations: Nursing Facility, NF, contains beds which accept Medicaid payment. Skilled Nursing Facility, SNF, contains beds which accept Medicare payment and may also take Medicaid payment, usually called Rehabilitation Unit. Beds certified in both are called dually certified beds. Medicaid. Medicaid is a state and federally administered insurance plan which can help individuals who require long-term care receive nursing care in a Medicaid-certified bed. Medicaid pays for skilled services and lower-intensity intermediate care. Medicaid also covers Medicare deductibles and up to 14 bed hold days per calendar year. Residents must meet Medicaid's patient need criteria to qualify. Generally, Medicaid becomes the primary payer when a resident exhausts the skilled nursing facility benefit to which they are entitled under terms of their Medicare coverage. If the prospective resident needs nursing care and will use Medicaid benefits immediately to pay for it, it may be difficult finding placement. That's because the resident's payment source is pending. Families should visit potential facilities, explain their need, and be open about finances. Also, they should cooperate fully in securing medical information required for admission and financial information for Medicaid applications. It's illegal for a facility to discriminate against applicants based on their source of payment, diagnoses, or disability. Nursing facility services include use of a room, equipment, and facilities, assistance with daily living, nursing, social, dietary, and laundry services, medical and surgical supplies, drugs ordered by a physician, and personal items routinely provided by the facility. Also included, if ordered by a physician, are X-rays, physical therapy, speech therapy, laboratory services, oxygen, and oxygen supplies. Many residents and families are shocked to learn that most or all of a resident's income must be applied to the nursing home bill to pay for medical care, meals, boarding, and supplies. Medicaid determines the portion of the monthly nursing home bill, or the patient liability, the resident is responsible to pay. For many single residents, the patient liability takes all of their monthly income except $60, which they may use for personal needs. Residents who choose to pay credit card bills, loans, etc., instead of paying their monthly patient liability to the nursing home, risk being discharged or evicted. Furthermore, it's against the law for families, legal representatives, or anyone to use a resident's money for themselves instead of the resident. Financial exploitation of a vulnerable adult is a serious crime. Who is eligible for Medicaid nursing facility services? Individuals who meet the following requirements. Check. Requirements. I'm talking like Elmer Fudd. I heard that. Okay. Here we go. Who is eligible for Medicaid nursing facility services? Individuals who meet the following requirements may be eligible. Reside in a facility that participates in the Kentucky Medicaid program and placed in a Medicaid-certified bed. Require and meet the level of care for skilled nursing services, nursing facility services, and intermediate care services for the intellectually and the developmentally disabled. Are ages 65 up, blind, disabled, or Medicaid eligible. Medicaid eligibility requirements are updated each year. Check Medicaid's website for the most accurate information. Be aware. It's important to be organized for your Medicaid appointments. Make copies of all requested documents and get a receipt for every piece of documentation you submit in support of your application. The resident may have to liquidate and spend down resources. For example, you may have to sell your second car and prove you used the proceeds to pay Medicaid allowable expenses. What resources will be considered? The resources of an individual residing in a nursing facility must be within Medicaid guidelines. For married applicants, resources of the spouse also are considered. Medicaid may deny a resident's application if he or she has too much value in financial resources. Resources are defined as cash money and any other personal property or real property that an individual or couple owns or has the right, authority, or power to convert to cash. Resources include, but are not limited to, checking and savings accounts, stocks, bonds, certificates of deposits, automobiles, land, buildings, burial reserves, and life insurance policies. Certain types of resources are excluded. They may include, but are not limited to, a home and adjoining land, household goods, personal effects, funeral expenses, one automobile used for employment or to obtain medical treatment, burial spaces and plots, life estate interest in real property, IRAs and KEOs under certain conditions, and are not considered in the Medicaid eligibility determination. A portion of a resident's home equity interest is an exempted asset for the first 6 months of his or her stay. After 6 months, Medicaid may request that the resident's home be put on the market for sale. The resident has the option to submit a statement of intent to return to that home with an estimated date, which would extend the exemption for another 6 months. Proceeds from the sale of a home are considered an available asset and disqualify the resident from receiving further Medicaid benefits until the money is spent on allowable expenses. Homestead property may be exempted when a community spouse, the spouse living at home, or certain other family members live there. Talk with a Medicaid representative to determine whether you qualify. Financial resources and the community spouse. At the request of either spouse or interested party representing the couple, the Department for Community-Based Services, DCBS, may perform an assessment of the combined countable resources of the spouse living in the nursing facility and the community spouse, the one living at home. The resource assessment, which may be completed without applying for Medicaid, involves documenting and verifying countable resources owned by the couple as of the date of the resident's most recent admission to the nursing facility. Both members of the couple receive a copy of the assessment. A single resident is allowed to retain $2,000 in non-excluded financial resources. Married couples who both reside in a nursing home have a resource limit of $2,000 each. If a nursing home resident has a spouse living in the community spouse may keep 50% of the couple's joint resources. Medicaid sets a minimum and maximum amount the community spouse may keep. The resident and spouse have 6 months from the application date to ensure the property is properly owned and therefore qualifies for the resource exclusion. DCBS staff can offer guidance in this matter. Any money a couple has over these limits will be used to pay the nursing facility bill and may make the resident ineligible for Medicaid. Transferred resources and the look-back period. If a resident transfers resources to another person, it may adversely affect the resident's ability to obtain Medicaid. A transfer of resources is defined as cash, liquid assets, personal property, or real property which is voluntarily transferred, sold, given away, or otherwise disposed of at less than fair market value. If resources are transferred 60 months prior to the Medicaid eligibility application month, It is presumed that the transfer of resources was for the sole purpose of establishing Medicaid eligibility. A Medicaid applicant will be penalized if the applicant gives the asset to a friend or family member or to satisfy a gift given in his or her will. If the agency determines that a prohibited transfer of resources occurred, an ineligibility period may be established beginning with the month resources were transferred. There are a few exceptions to the transfer rule. A resident may transfer his or her home without penalty to the following persons: a spouse, a child who is under age 21 or a disabled child of any age, a child who has lived with the resident and provided care for the resident for at least 2 years, thereby avoiding institutionalization of the prospective resident, a sibling who has equity interest in the home and lived with the resident for 1 year prior to institutionalization for 1 year and provided care for the resident. The living arrangement must be documented with statements by 2 collateral sources, such as a neighbor, physician, minister, etc. Family members are not considered a collateral source. Income requirements. For the purposes of qualifying for Medicaid, income is defined as money received from statutory benefits such as Social Security, VA pension, black lung benefits, and railroad retirement benefits, pension plans, rental property, investments, or wages for labor and services. Income may be earned or unearned. If the nursing facility resident's net monthly income is at or below the income eligibility amount, the nursing facility resident is income eligible. The net monthly income eligibility amount changes each year. Call Medicaid or the NHOA office for updated information. Those with income exceeding the eligibility income amount can still qualify for Medicaid nursing facility coverage by placing all of their excess income into a qualifying income trust, QIT. In most cases, income in excess of the eligibility income will be placed in the trust and can be used to pay for the resident's care, according to the terms of the trust. Legal assistance is required to draft the trust. Patient liability. The portion of the nursing home bill a resident receiving Medicaid must pay is known as patient liability. Patient liability is determined by considering the resident's gross income and allowing a deduction of $60 for personal needs, an income allowance for a community spouse, health insurance premiums, and deductions for medical expenses approved by Medicaid. The remaining amount is the resident's patient liability to be paid to the nursing facility. How do I apply? The Department for Community-Based Services, DCBS, processes Medicaid applications for the Kentucky Department of Medicaid. An application for Medicaid may be filed at the local Department for Community-Based Services office. To begin the application process, call 1-855-306-8959 to to request an appointment. You may also call this number to ask questions, express concerns, and to check the status of your case. Prepare for your appointment by gathering the following documents: gross income, earned and unearned, certificates of deposit statement, life insurance policies with most recent statement showing cash value, prepaid burial arrangements or irrevocable burial trusts, deeds to real estate, health insurance, medical bills, Social Security number, bank statements, proof of identity with photo, birth certificate or other proof of citizenship, IRA and annuity statements, broker statement of investment portfolio. This list is not all-inclusive. Other documents may be required to complete an application for Medicaid eligibility. Resource and income limits usually change in January to adjust for inflation. What do I do if my application is denied? Residents have the right to appeal Medicaid's decision to deny long-term care coverage. Appeals must be filed within 30 days of the date on the denial letter. Legal assistance may be needed to file the appeal. Legal aid of the Bluegrass, 1-800-888-8189, is one source of assistance for residents with Medicaid denials. Medicaid estate recovery. The state may try to recover costs for medical care that Medicaid has paid during an individual's lifetime. This is called Medicaid estate recovery. Anyone who receives services in a nursing facility or receives home and community-based services as an alternative to nursing facility care is subject to this policy. Under certain circumstances, Medicaid estate recovery may be waived. Contact an attorney with questions. For more information, changes to these and other regulations can occur at any time. Consumers should consult the Department for Medicaid Services website for the most current information. The web address is https://cahy.gov/agencies/DMS/pages/default.aspx. You may also call 1-855-306-8959 to speak with a Medicaid representative. Medicare. This federal medical insurance program is available to some disabled younger persons and persons over the age of 65. It covers skilled care for a short period of time and for certain reasons. When a facility staff member says she's skilled, it can mean one or all of the following: Medicare is paying the bill, resident has complex care needs, individual lives in the skilled care part of the facility. Part A covers facility charges. Part B covers health care provider services, outpatient care, durable medical equipment, home health care, and some preventive services. And Part D covers medication. Skilled care refers to services provided by medical professionals such as registered nurses, physical therapists, dentists, occupational therapists, audiologists, etc. To qualify for skilled care, an individual must require professional services on a daily basis. In addition, services must be those that can only be provided on an inpatient basis. Benefit period is the way Medicare measures days in the hospital and in a skilled nursing facility, SNF. For a hospital inpatient stay, the first 60 days are covered by Part A, which picks up all covered expenses except for the Part A deductible. If there is an extended hospital stay past 60 days, days 61 to 90 have a coinsurance cost for each day. The resident is responsible for this amount. A hospital stay longer than 90 days is eligible for lifetime reserve days. A beneficiary has 60 lifetime reserve days for stays longer than 90 days. These can be used for one day or used all at once. The resident is responsible for the copayment for each day. 60 days must pass between a discharge and readmission for the resident to be in a new benefit period. The hospital can't bill for the deductible unless the person is in a new benefit period. For the first 20 days in a nursing facility, Part A picks up all covered services. For days 21 to 100, there is a coinsurance cost for each day. The resident may use Medicaid, Medigap insurance, or cash for the copayment. A day is counted when the resident is present for the midnight census. If readmission occurs within 30 days of discharge from the SNF, the SNF benefit period picks up at day of discharge. If readmission occurs after 30 days, a 3-day hospital stay is required before renewal of SNF benefits. The qualifying 3-day hospital stay expires if long-term care is not used within 30 days of hospitalization. Does Medicare pay for custodial care? Medicare does not pay for assistance with activities of daily living, also known as custodial care. Examples include getting in and out of bed, eating, bathing, dressing, and toileting. However, Medicare may cover treatments that must be administered by someone with professional skills or training. What if Medicare won't pay for a therapy my loved one needs? Residents have the right to ask the facility to submit a demand bill to Medicare when Medicare denies benefits. An outside, impartial medical professional will review the denial of benefits. Medicare has 3 days to uphold or reverse the facility's decision. The resident isn't obligated to pay for those 3 days, regardless of Medicare's decision. If the decision goes against the resident may appeal. If the resident loses the appeal, he or she must pay the bill. It's important to note that if Medicare stops paying for a particular therapy, it doesn't necessarily mean that the resident no longer needs the therapy. It may mean that the individual has met the maximum allowable benefit for therapy. The facility must notify the resident and family of the cost for therapy in advance should they decide to continue with it. Nursing facilities frequently tell residents they are being discharged from Medicare because they aren't improving or have plateaued. However, a resident may still qualify for Medicare coverage as they plateau. The Jimmo versus Sibelius settlement in 2013 affirmed Medicare coverage of professional nursing and therapy services needed to maintain a resident's function or prevent or to slow the resident's deterioration or decline. The settlement applies both to traditional Medicare, Parts A and B, and to Medicare Advantage plans, managed care. It firmly rejects as inconsistent with the Medicare law erroneous statements that Medicare won't pay for additional days of care when the resident has plateaued or is not improving. Residents and families often misinterpret a discharge from Medicare to mean they're being discharged from the facility. However, residents may appeal the Medicare discharge or use another payor source to remain in the nursing home. Medicare Part B. When the beneficiary, resident, in a Medicare-certified skilled nursing facility is not entitled to Part A benefits, limited benefits are provided under Part B. The following services may be billed by the skilled nursing facility or the rendering provider or supplier under an arrangement with the skilled nursing facility. They include, but are not limited to, diagnostic laboratory tests, X-rays, hospital outpatient and ambulance services, purchase and rental of durable medical equipment, orthotic, prosthetic devices, and surgical dressings. Medicare Part D. The facility can provide residents with information about enrolling in Medicare Part D and inform them about which prescription drug plans include the pharmacy the facility uses. Generally, the resident or their legal representative must actually select the plan. Residents who are dually eligible for both Medicare and Medicaid and who do not select a plan will be randomly enrolled in a plan without regard for how well the plan covers what the resident needs. It is important for residents to choose a plan that will cover the drugs they are taking from a pharmacy that contracts with the facility in which they are residing. Unlike those in the community, persons living in nursing facilities will be allowed to change plans every 30 days in order to maximize their coverage. Contact Medicare. For more information about your Medicare plan, visit www.mymedicare.gov or call 1-800-MEDICARE. That is 1-800-633-4227. How do I appeal Medicare's denial to pay for services? To file an appeal, ask your physician or healthcare provider for any information that may help your case. If you have a Medicare Advantage plan, look at your plan information, call your plan provider, or go to www.medicare.gov to learn how to file an appeal. If you have traditional Medicare, read the Medicare Summary Notice, MSN, which lists the item or service you will appeal. The MSN is the quarterly statement that lists services billed to Medicare and whether Medicare paid for them. Then, do the following. Circle the item or items on the MSN you disagree with and write the reason you disagree on the MSN document. Include your telephone number, Medicare number, and sign the document. Keep a copy for your records. Please include any additional helpful information on the MSN and send it to the Medicare contractor's address listed on the MSN. You must file the appeal within 120 days of the date you receive the MSN. Read the MSN carefully and follow instructions if you plan to file an appeal. Contact your State Health Insurance Assistance Program, SHIP, at 1-877-293-7447 if you need help filing an appeal. Hospital discharge planning. Role of the hospital discharge planner. When a patient is hospitalized, it can be a very difficult time for the patient and family. Hospitals have discharge planners who assist families when a patient is being discharged from a hospital. They are there to support the family and help the elder through the hospital stay. Discharge planners are usually social workers, but sometimes are nurses or other healthcare professionals. The discharge planner's role in helping the patient will vary depending on the patient's needs and family's request for services, but the primary role of the discharge planner is to help the patient make decisions, provide support, and coordinate needed services after the hospital stay. How can discharge planners help the family? Discharge planners can help families in many ways when a patient is hospitalized. Before the patient is discharged from the hospital, a discharge planner will assess their needs, discuss these needs with the family, and develop a plan of action. An assessment of evaluation is completed to help the discharge planner determine what level of care is needed, so the patient can maintain the maximum level of independence after the hospital stay. Discharge planners are also advocates. If concerns are expressed during the patient's hospital stay, the discharge planner will help resolve matters. They will also help the family with payment issues. Sometimes Medicare will discontinue payment, and the family will receive a notice of non-coverage. If this happens, the family has the right to appeal this decision to a peer review organization. The discharge planner will usually help the family understand the forms and assist with the appeal process. The most important and primary role of the discharge planner is coordinating services. After an assessment is completed, the patient's needs are identified and discussed with the family. The discharge planner will coordinate any services that are needed. Options after discharge. Sometimes patients are discharged from a hospital stay and cannot function at home without some kind of assistance. Home health care may be needed and ordered by the physician. Medicare will cover home health care if the doctor orders the patient needs skilled care at home to rehabilitate. Discharge planners can also coordinate other needed services that Medicare will not cover, such as Meals on Wheels, hot, nutritious meals delivered to the home services, light housekeeping, laundry, and meal preparation, arrange for transportation, or help find a private duty sitter or companion. Many services exist in the community to help patients so they can remain at home. Discharge planners will explain to the family the options available and refer the family to the appropriate agency that can provide the needed services. Sometimes the patient is unable to return home and needs to be temporarily in a nursing home or possibly long-term if unable to rehabilitate due to a serious injury or condition. Nursing homes can provide 24-hour nursing care and intensive therapy that cannot be provided in someone's home. Being discharged to a nursing home may be the best option if the patient needs intensive rehabilitation. It is important to know that it is easier to be admitted to a nursing home coming from a hospital stay than coming from home. So consider all the options available before making a decision to be discharged home if intensive rehabilitation is needed. Discharge planners will help the family with this decision and locate an appropriate nursing home. What can the family do to help? The family should write down a list of concerns and questions so it can be addressed when meeting with the discharge planner. Also, it is important that the family be assertive while the patient is hospitalized. If a discharge planner has not initiated contact with the family, go ahead and locate this person. Sometimes patients are discharged without the assistance of a discharge planner. Remember, every hospital has a discharge planner, so make sure they are providing the services that are needed to help the family through this process. What to expect on moving day. Will I have to sign a contract? Yes. An admission contract is a legally binding document that describes the relationship between the nursing facility and the resident, services the facility provides, the rights and responsibilities of the resident, and the amounts charged for care. The facility is required to use clear language, both written and oral, to inform residents of services they will receive. A copy of the signed contract services must be kept in the resident's file. This is a legally binding document. Therefore, it is crucial to read carefully and understand it before signing. The facility wrote the contract and took care to ensure it protects the facility's interests first. Admission contracts may contain misleading and unenforceable clauses. Some attempt to convince residents that they have fewer rights than they actually have, and that the facility has fewer responsibilities than it actually does. Obtain a copy of the signed contract before leaving the building. Information regarding residents' rights and contact information for the ombudsman working in that facility may be included in the packet of information the facility gives new residents and families. Be aware, when entering a nursing facility, you do not have to sign papers that require mandatory arbitration in the event of a dispute with the nursing facility. You can ask that any arbitration provisions be stricken from the contract prior to signing. By law, a nursing facility must not require another person, commonly known as responsible or third party, to guarantee payments as a condition of a resident's admission or continued stay. Will I have to pay a deposit? Nursing facilities often require an individual seeking placement to make a cash deposit as a condition of admission if the bill won't be covered by Medicare or Medicaid. Facilities may not require a deposit for admission of an individual covered by Medicare or Medicaid. Require prepayment as a condition of admission for care covered by either Medicare or Medicaid. Require a third-party guarantor for a Medicaid-eligible applicant as a condition of admission. Facilities may request that the Medicare beneficiary, resident, pay co-insurance amounts and other charges for which he or she is responsible. These charges should be paid as they become due, but not in advance. Collect a refundable security deposit if the resident has applied for Medicaid but hasn't received a letter regarding determination of eligibility. If the resident is later determined to be eligible, the facility must refund the deposit prior to billing Medicaid. What emotional reactions can we expect from our loved one? Moving to a nursing facility is a life-changing event. Residents may feel angry, abandoned, and depressed. Families may feel regret, guilt, doubt, and frustration. Encourage family members to openly discuss their feelings. The ombudsman and facility staff can help by giving the resident time to adjust to his or her new surroundings. Spending extra time with him or her in the beginning can relieve feelings of abandonment. To further smooth the transition, include the resident in decisions about care, visitors, outings, and room furnishings. May we personalize the room? Most residents have a roommate, which limits space for personal belongings. Nonetheless, it's important to make the room feel home-like. This can be accomplished by bringing a small bookcase, side table, comfortable bedside chair, photographs, clock radio, pillows, and toiletries. To protect your belongings, make sure you fill out the inventory form and update it regularly. Rather than placing an original family photograph in the resident's room, make a copy that can be replaced if lost or damaged. How do I protect personal belongings? Label everything with the resident's first and last name, even if a family member or friend is doing the laundry. Things often get placed in the facility's laundry by mistake. There should be a personal inventory list for every resident at the nurse's station. This list includes hearing aids, glasses, televisions, phones, and all other belongings. When you take your loved one something new, label it and add it to the list. Likewise, delete items from the list when you remove them from the permanent facility. Regardless of measures taken to prevent theft, it happens. Keep expensive or sentimental belongings, such as jewelry, in a safe place outside the facility or in a lockable bedside drawer. Many families take photos of the resident with their personal belongings, so there is a record in case of loss. Photos can depict the resident wearing dentures, hearing aids, glasses, sitting in his or her own wheelchair, or covered by a favorite quilt. Obtain the resident's permission before taking photos. Hearing aids have a serial number that can be recorded in the resident's chart. Some styles, such as those worn behind the ear, can be fitted with a chain and clip that attaches to the wearer's shirt. Ask the dentist about engraving your loved one's dentures. It's easier to get dentures engraved at the time they're made. However, they can be engraved later. Nursing facility titles and responsibilities. Activities Director directs activities for residents, including group events or in-room activities. Activities Assistant assists the Activities Director in helping residents participate in varying activities within the facility. Administrator responsible for running the nursing facility, supervising staff, and communicating with families. Beautician or barber provides hair salon services to residents. This person often works under a contract with the facility and sets the rate for services. Business Manager manages resident accounts and billing. Kentucky Medication Aid, KMA, an aid that is certified to dispense medications to residents. Dietary Manager manages the kitchen of the facility. Dietitian oversees meeting the nutritional needs of residents. Some facilities contract with dietitians for this service, and the dietitian makes periodic visits to the facility. Director of Nursing, DON, supervises nursing staff and nursing needs of residents. The DON also is a registered nurse, RN. Head of Housekeeping manages the housekeeping department, responsible for cleanliness of the facility and laundry services. Head of Maintenance oversees the maintenance of the facility. Licensed Practical Nurse, LPN, works under the direction of the DON, supervises state registered nurse aid, and provides direct care to residents. Medical Director, physician responsible for medical care of all residents, required by law to visit the resident once in a 3-month period. Some send physician's assistants and/or nurse practitioners in their place. Occupational Therapist fits residents with assistive devices such as wheelchairs, positioning cushions, walkers, etc. Physical Therapist provides help with movement through a program of exercises. Registered Nurse, RN, provide and coordinate patient care, educate patients and the public about various health conditions, and provide advice and emotional support to patients and their families. Restorative Therapist works under the supervision of the physical therapist to provide range of motion exercises to residents. Social worker helps residents and families with any personal concerns, including problems within the facility, financial concerns, psychosocial needs, obtaining medical devices such as hearing aids, glasses, dentures, and wheelchairs. If a facility has more than 120 beds, it must have a certified social worker. Speech therapist, trained to help individuals with speech and swallowing problems. State Registered Nurse Aide, SRNA, gives direct care to residents, including bathing, feeding, and dressing, under the supervision of the nursing staff. Unit or charge nurse works under the supervision of the DON and is usually responsible for the care of residents and supervision of nursing assistants for a particular area, hall, or unit in a nursing facility. Contact your ombudsman. The ombudsman is a good source of information about the workings of the facility. He or she can identify the change makers in your facility so you don't waste time and energy addressing complaints to the wrong person. Resident care requirements in nursing facilities. What's a care plan? A care plan is a document that describes how facility staff will meet a resident's individual needs and preferences. It's developed at the initial care planning conference, reviewed every 3 months, and revised as the resident's needs change. At a care planning conference, staff, residents, family, and/or the resident's chosen representative may talk and ask questions about aspects of life in the facility: medication, personal care, staff, activities, exercise, therapies, food, and use of restraints are a few topics that may come up. Residents and their families or representatives should share information that will help staff provide individualized care. These may include reviewing medical and care records prior to the care plan meeting. A good care plan should be specific, individualized, and written in language that everyone can understand. Reflect the resident's interests as well as needs and support the resident's well-being, functioning, and rights. Use a multidisciplinary team approach and use outside referrals as needed. Be re-evaluated and revised every 3 months. Family's role in care plan. Support your residents' agenda, personal choices, and participation in the care plan meeting. Even if your resident has dementia, involve him or her in care planning as much as possible. Always assume he or she may understand and communicate at some level. Help the staff find ways to communicate with your resident. Get a copy of the care plan. Monitor the care plan and talk with staff if questions arise. The ombudsman is available to assist in preparing for the meeting and to attend at the resident's request. Are there federal and state standards of care? The Federal and Kentucky Nursing Home Reform Acts and regulations set daily care requirements for nursing facilities. Federal law applies only to Medicare and Medicaid-approved nursing facilities. Kentucky law applies to all Kentucky nursing facilities. Most Kentucky nursing facilities are Medicare or Medicaid approved. Federal law contains 4 key standards for nursing facility care. The nursing facility must provide services to help each resident attain or maintain the highest practicable physical, mental, and psychosocial well-being. A resident's ability to bathe, dress, groom, transfer, walk, toilet, eat, and communicate must not decline unless it's medically unavoidable. If a resident is unable to carry out activities of daily living, he or she must receive help to maintain good nutrition, grooming, and personal and oral hygiene. Residents have the right to make choices about their care. In addition, Kentucky and federal laws set minimum requirements for nursing homes in providing daily care. They include, but are not limited to, the following: general hygiene. The nursing home should provide help with general personal hygiene, skin, oral, and hair, for those who need it. Residents should have the opportunity to shave daily with assistance if needed. Residents should receive help to take a full bath or shower as often as needed. Pressure sores. Residents who sit or lie in one position for long periods of time often develop pressure sores, also known as bed sores. Pressure on the skin from prolonged sitting or lying without changing position prevents blood vessels from carrying nutrients to the affected area. Skin breakdowns can lead to large sores, infections, and severe pain if left untreated. Poor nutrition and certain conditions also may result in pressure ulcers. Residents confined to a bed or chair should be checked and repositioned, turned, every 2 hours or more often, if the resident is uncomfortable. The facility should use supportive devices, special mattresses, pads, and pillows to maintain normal body posture and relieve pressure. Facility staff should provide daily help with walking and exercise to maintain or improve circulation, strength, and use of the body. Dressing. Residents should be dressed in their own clean, comfortable clothing each day. Residents who walk should wear appropriate footwear. Non-ambulatory residents should wear suitable foot coverings when out of bed. Toileting. Residents who have control of their bowel and bladder should receive help using the toilet as often as needed. Those who are incontinent, no control of bowels or bladder, and become wet or soiled, should be cleaned and changed quickly. Incontinent residents should receive care to restore as much normal bowel and bladder function as possible. Eating. Facility staff should assist residents as needed during meals. This may include opening packages, securing special utensils, and helping residents eat. Food normally eaten hot should be served hot, and food normally eaten cold should be served cold. Fluid intake. The nursing facility must ensure that residents receive sufficient fluids to maintain good health and prevent dehydration. Fresh water and drinking cups must be on each bedside table. Vital signs. Facility staff must weigh and check blood pressure, temperature, respiration rate, and pulse of residents upon admission. This should be repeated monthly, at minimum, and more often if ordered by a physician. Special needs. Facility staff must arrange for special services such as dental, podiatry, vision and hearing, physical, speech, and occupational therapy, mental health evaluation and treatment, and respiratory care. This guide summarizes some, but not all, of the daily care requirements Kentucky nursing facilities must meet. Please contact our office at 859-277-9215 with questions about these and other requirements. Friends, family, and chosen family, relationships with residents. Guardian. When the court determines an individual is incompetent, the individual loses all rights as an adult, and a guardian is named. The guardian oversees all of the individual's affairs. For information about guardianship, visit http://www.kypa.net/home. You may also call your county clerk for information. Limited guardianship. Limited guardianship is determined through the same procedure as guardianship and is used when a person is unable to make decisions about his or her personal care. The court grants personal care rights only to the limited guardian. Conservator. A conservator may be appointed to handle the resident's finances if the court finds that the resident is unable to handle his or her financial affairs but is capable of making his or her own personal care decisions. Power of attorney. An individual may appoint another individual power of attorney, POA. Powers of attorney are generally used to handle specific tasks such as paying bills, depositing checks, etc. Power of attorney ceases when an individual becomes mentally incapacitated unless the POA also is a durable POA. The person who has power of attorney is known as the attorney in fact. Never give anyone who isn't completely trustworthy power of attorney. Durable POA. Durable POA differs from regular POA. Durable POA specifically states that authority continues even in cases of disability. Next of kin. Next of kin refers to the resident's closest relative or relatives. No legal obligation is implied. Interested family member. The nursing facility may designate a family member or close friend as an interested family member, IFM. This is not a legal designation. The interested family member and the resident may terminate the relationship at any time. The nursing facility may ask the interested family member to make certain decisions regarding the resident's care and to do things for the resident, such as buy clothing. Representative payee. The person or nursing facility designated by the Social Security Administration, SSA, or Veterans Administration, VA, to receive a benefit check on behalf of another person is the representative payee. For example, a check for James Smith is paid to Lucy Jones, and Lucy pays the facility. The benefit check also may be sent directly to the facility if the facility is the payee. The designation may be altered by requesting a change at the SSA or VA office. Contact the Social Security Administration. If you have questions about Social Security benefits, call 1-800-772-1213 or visit www.ssa.gov. Contact the Department of Veterans Affairs. For information about health care benefits through the VA, call the U.S. Department of Veterans Affairs at 1-877-222-8387 or visit www.va.gov. Contact Legal Services. For information on how to file for a power of attorney, call your local legal service provider. The right to care without discrimination. Do civil rights laws apply to nursing facilities? Almost all Kentucky nursing facilities participate in the federal Medicare or Medicaid programs. To do so, they must agree to not discriminate against people seeking care on the basis of race, national origin, age, religion, sex, color, or physical or mental disability. Kentucky law, which covers all nursing facilities in Kentucky, also prohibits certain other types of discrimination. What should I do if discrimination occurs? You may file a complaint online or by phone at the address and phone number provided by your ombudsman. If you believe your loved one has experienced discrimination based on race, color, national origin, age, sex, handicap, or religion by a Medicare or Medicaid-approved nursing facility, the Office for Civil Rights, a division of the United States Department of Health and Human Services, DHHS, makes sure organizations receiving federal funds comply with civil rights laws. If the Office for Civil Rights determines a resident is the subject of discrimination, it will work with the nursing facility to correct the discriminatory action. For example, if the facility improperly denied admission to an individual, it may be asked to grant admission to the individual and announce to the community that it will not discriminate against future applicants. The Civil Rights Office also may suspend or terminate federal funding if the facility doesn't take corrective action. Written complaints must be signed and contain the following information: name, address, and telephone number of the person being discriminated against, name and address of the facility you believe discriminated against you or your loved one, how, why, and when you believe the discrimination took place, and any other relevant information. The Civil Rights Office will send a discrimination complaint form to those who prefer to complete a form rather than write a letter. Send complaints or request a complaint form by contacting and working with your ombudsman. Restraints. What are physical restraints? Physical restraints are anything used to restrict, restrain, or prevent movement of a person. Examples include belts, vest restraints, cuffs, and sometimes special chairs or bedside rails. The same item may not be considered a restraint if it is used to enable a resident in some way. For example, a bed rail may be used to prevent a person from getting out of bed or to help a resident turn over in bed. What are chemical restraints? A chemical restraint is the use of a drug to control an individual's behavior. A nursing home may use chemical restraints when they perceive a resident as having a behavior problem. Chemical restraints are often antipsychotic or psychotropic medications, which can be dangerous when prescribed to elderly residents. Antipsychotic and psychotropic medications are inappropriate if there's no corresponding diagnosis, there's no documented benefit to the resident, dose is too high, dose reductions are not followed. What are the federal guidelines regarding restraints? Federal and state laws prohibit nursing facilities from using restraints unless prescribed by a physician for a specific purpose and limited time. Facilities must ensure that restraints don't impede a resident's ability to bathe, dress, walk, toilet, eat, and communicate. These abilities should not decline due to the use of restraints. Residents must be released from physical restraints and repositioned at least every 2 hours. Physical restraints may only be applied by a qualified professional. Nursing facilities sometimes use restraints to keep residents in proper body alignment or position. However, proper positioning can often be achieved by using pillows, pads, or comfortable chairs. Can restraints have a negative impact? Restraints rarely prevent injuries, and they often create other serious problems. Physical restraints may cause chronic constipation, incontinence, pressure sores, emotional problems, isolation, and loss of the ability to walk or perform other activities. Residents may also be harmed by improperly applied restraints or while trying to escape a restraint. Chemical restraints can cause serious medical complications, including oversedation, leading to similar issues caused by physical restraints. Chemical restraints can also cause falls, confusion, and even death. What are the rights of nursing facility residents regarding the use of restraints? Residents have the right to refuse treatment, including the use of restraints. Restraints must never be used as a permanent means of control, form of punishment, convenience for the facility staff, or substitute for activities or treatment. How do I prevent unnecessary use of restraints? Make sure the nursing facility conducts a careful assessment and considers all options before using restraints. If facility staff know you're well informed on the subject, they are more likely to respect your wishes. For further assistance, contact the Nursing Home Ombudsman Agency of the Bluegrass at 859-277-9215. History and mission of the Nursing Home Ombudsman Agency of the Bluegrass, Incorporated, also known as NHOA. Founded in 1981 and headquartered in Lexington, Kentucky, NHOA is an independent, nonprofit organization that relies on financial support from individuals and organizations to fulfill its mission. NHOA provides certified long-term care ombudsmen to advocate for residents. They do this by establishing relationships with residents and families. Residents know they have an advocate at their side at all times, which makes them feel protected and loved. NHOA serves everyone who needs assistance, regardless of age, race, ethnicity, religion, gender, sexual orientation, gender identity, national origin, and disability. There's never a charge for NHOA's services, thanks to the regular, loyal support of many individuals and organizations. NHOA houses the office of the Kentucky State Long-Term Care Ombudsman and the Bluegrass District Long-Term Care Program. The Bluegrass District Program serves the 17 counties of the Bluegrass Area Development District, including Anderson, Bourbon, Boyle, Clark, Estill, Fayette, Franklin, Garrett, Harrison, Jessamine, Lincoln, Madison, Mercer, Nicholas, Powell, Scott, and Woodford. NHOA is nationally recognized for its low resident-to-ombudsman ratio. Our ombudsmen are part-time employees who live near the facilities they serve. A model ombudsman program dedicated to implementing innovative, research-based practices. We freely share information and training guides with other ombudsman organizations throughout the United States. Although ombudsmen empower and encourage residents and families to advocate for themselves, they know this isn't always possible. They understand the power imbalance in the resident-caregiver relationship. Therefore, they're always available to step forward for residents. With the residents' consent, ombudsmen investigate complaints. They share the results of the investigation with the resident and/or the resident's legal representative and explain options for resolving concerns. They also follow up with residents to make sure problems are resolved and solutions remain in effect. Ombudsmen also guide families through the complex nursing facility system. They know where to find information about services, rights, benefits, and regulations. Ombudsmen can connect residents and families to family councils and resident councils in their facilities. They also are available to accompany residents and families to care plan and other meetings with facility staff. Ombudsmen can assist in reporting abuse, neglect, and exploitation to state officials. In Kentucky, anyone who suspects abuse has occurred is required to report it to Adult Protective Services, APS, by calling 1-800-752-6200. This can be done anonymously. The Office of Inspector General's Division of Health Care, OIG, is a state agency that inspects facilities. OIG investigates to determine if facilities have violated state and federal regulations. Consumers may file reports directly by calling OIG at 1-502-564-7963. NHOA also may make reports on behalf of residents.